kisser. Sophia, best girl. Life and material. 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 Do I look like a cam girl to you? I need this for drugs. To enter my fortress of SovCit. Hello, everybody. It is Artie of Artie's Corporate Fiction, and it feels like it's been ages since we've done this last time. In between Thanksgiving vacation and me coming down with the sickness. Shout out to Disturbed. Yeah, it's been a while. So welcome, everybody. As promised, we have a good show, I think, with brand new, uncut, unfiltered, never before seen, organic, free range, cage free content that has not been perused yet by the rest of the community. The only reason why I hype on that is because we all know that Van Balian gets the lion's share of all the fresh sovereign citizen content out there. Not that I hate him for it, but he's always the first, and it's always something special when I can find something before he does. But, I mean, that's because Van Balian's a legend, and it's hard for me to keep up. So, I'll first show you guys something that I think I've showcased this before. We're gonna go right to the main area here. I think I've actually shown this video to you guys before. I can't recall when, but I'm about 99% sure I've shown this to you before. So we're gonna go and have our own little bit of a recap here.
Hello. Hereby special appearance.
Mr. Brennan, do you have a camera on your device?
Excuse me, sir?
Do you have a camera on your device?
He does, but I just now noticed that he put tape over the camera. I didn't even notice that until just now. Why did he do that?
I do not know, sir. I'm not very tech savvy.
So he's lying already.
What is your address?
52 Bowline Street, Beechwood, New Jersey.
Were you ever at 444 Cable Avenue in Beechwood?
Yes, I was.
All right, what is your date of birth?
1965.
Mr. Brennan, you've been charged with several motor vehicle violations, included among them is a charge of driving while suspended. And I'm going to arraign you on that charge at this time. Do you understand that?
Sir, I'm here by special appearance.
Sir, that's irrelevant to what I just said to you.
No, that's not irrelevant, sir. That's a challenge.
Don't interrupt me. I'm going to arraign you on this charge at this time. Are you refusing to be arraigned? If so, I'll remove you from the meeting.
Sir, what I am doing is challenging the jurisdiction of the court. There's no subject matter jurisdiction, nor is there personal jurisdiction.
I'm not hearing that application at this time, sir. Simply arraigning you at this time. If you refuse to be arraigned, I'll remove you from the meeting. You'll be treated as if you did not appear here today.
Sir, I appeared here today. I have appeared here today and through a special appearance, and I'm challenging the jurisdiction of the court. The court needs to have jurisdiction before they can, move the matter. Also,
Mr. Brennan, I know what jurisdiction is. I've been doing it a long time, although I appreciate your piece of advice in this matter. And I'm telling you the last time, because I'm not going to keep going back and forth, that I'm not hearing any applications or motions regarding the jurisdiction of this court. I am only scheduling you, or have scheduled you today, for an arraignment on this matter. If you refuse to let me conduct the arraignment, I will remove you from the court session, and you'll be treated as if you did not appear here today. Last time, are you going to allow me to conduct this arraignment?
is there a charging instrument submitted to the court?
Please remove Mr. Brennan.
Okay, of course.
And be treated as if you did not appear here today.
No, that's not true. That's a lie.
Off the record.
Arguably, I think one of my favorite. I feel like eventually, if I get off my lazy butt, I have to put together a top 10 bench slaps of the year to end the year, and this is definitely going on my top 10 list. But I love the judge. He wasn't going to deal with his nonsense. He wasn't going to entertain any of it. He's like, I'm giving you several chances. We're not hearing that today. Are you going to allow me to arraign you? And hey, fine, be that way. So now we get to go to the trial of the matter. Now, I will note that it sounds to me that the judge at the trial is not the same judge as at arraignment. So I want to make that known. Let me bring that up. Eventually. And of course, because this guy does not know how to video, I have to do some effects here and transform the video 90 degrees so that we're not tilting our heads while watching this thing. And meanwhile,
Good morning. How are you?
I believe this starts at around, his trial starts at around 4.5 minutes. There you go.
This is the trial date for.
Unfortunately, we're going to be staring at the ceiling for most of the hour. I apologize. I probably should have played some sort of video game while this is going on because there's really nothing to see. But I'll try my best to turn up the audio as much as I can so that we can hear the judge, which is a judge and the prosecutor, which is going to be a little bit difficult.
Matter of Donald Brown Jr., lead summons 41264, 41265, 66, and 67. Good morning, you are Donald Brennan.
I am Donald Brennan, yes.
Welcome. Please have a seat as well. Counsel, you're finished for the record?
Yes, James Nelson Butler Jr. came on behalf of the Borough of Shrewsbury, State of New Jersey.
Great state of New Jersey. New Jersey.
The designated trial date for those summonses. Again, I want to make sure that everyone is aware of the allegations in each of those summonses. As to summons 41264 is a violation of 39340, driving while on the suspended list. 41265, a violation alleged of 39310B, not having driving without a valid license, having had a valid license in New Jersey. 41266, 39329B, failure to have an insurance card.
Oh, actually, I wanna need to repeat because I want to pay attention to the exact charges that are being hailed.
To make sure that everyone is. This is the designated trial date for those summonses. Again, I want to make sure that everyone is aware of the allegations in each of those summonses. As to summons 41264 is a violation of 39340, driving while on the suspended list.
The driving while suspended license.
41265, a violation alleged of 39310B, not having driving without a valid license.
Driving without a valid license.
Having had a valid license in
While once having had a valid license.
41266, 39329B, failure to have an insurance card in your
Failure to provide insurance.
registration in your card in your possession.
And failure of registration. So the classic triple whammy of right to travel: no license, no registration, no insurance.
In New Jersey. 41266, 39329B, failure to have an insurance card in your possession. Registration in your card.
Oh no, he corrected himself. It's actually it was registration that he didn't have.
In your possession. And lastly, 41267, a violation alleged of 39329C, failure to have an insurance card.
Oh, there it is. Well, never mind. I'm sorry. He got the ticket wrong.
Mr. Brennan, you were arraigned.
So yes, the triple whammy.
July 20th. After some failures to appear, again, each of these is alleged to occur on March 18 of 2022. But I just want to make sure that you're clear. You understand that if convicted of either of the first two charges, the first charge alone, 39340, driving while on the suspended list, if this is not a first offense, then the statute requires that I impose jail time as well.
So if you didn't hear that, if this is his second or more, or if this is not his first offense, for driving on a suspended license, and he's convicted, or at least if this is his second conviction, he gets mandatory jail time.
In addition to any fines or other penalties, including suspension of license. Similarly, the 39310B charge carries with it a significant fine of $500 if you're convicted of driving without a valid license, having had a valid license in the past as well. The other two charges are minor monetary fines as well. And again, as you were advised back when we arraigned you in July of 2022, on July 20th, you have the right to be represented by an attorney or to apply for the appointment of a public defender. You declined at that time, indicated that you wished to represent yourself going forward, and that has been the case since then. Again, I offered the opportunity to apply for the appointment of a public defender because of the potential severity of the consequences. Do you want to waive that right and to proceed today?
Sir, today I'm here at arm's length to the court, and to this day, there still is no primary pleadings that have been submitted into the record. There's no elements to support a cause of action whatsoever.
I'm certainly happy to hear all of those arguments when we start the trial. The question...
In New Jersey, the citation is the complaint. And I imagine that's the case in the vast majority of other states.
Right now, if you want to waive any right to apply for the equipment.
I'm not waiving any rights, and I don't understand how the court can proceed without subject matter jurisdiction.
Now, you have made that application in the past. It was denied, and I know you recently filed on October 31st. And then another indication, you called it an introduction and I take it a declaration.
Affirmative defense?
Right. I have read that. We can address that certainly during the course as well.
Yes, well, the court, without proper service. Let me ask you a question, sir. If I was to sue you in court, can I scribble on a piece of paper something that says a summons and send it to you, and you're required to appear in court?
Well, that's not this situation.
Well, certainly it is, because that's what your officer has done.
I'll hear that argument if you'd like.
Okay.
And why don't we address at least your initial indication? There are certain of the allegations that are not cognizable in this court.
Okay.
But certainly you have, again, raised the indication that there's been a lack of service process.
Yes, there
has. A lack
has.
of in personam jurisdiction.
Yes, there is.
And you believe that the statutes have not been satisfied as to those two items. I previously denied those.
So he's raising arguments again that there is no proper service, and no service of process, and what was it, in personam jurisdiction or in personam jurisdiction. The judge has telling him that you had raised these issues before and I had already denied them.
That application. The statute provides that service of a summons by a duly appointed officer upon you at the time of the stop constitutes in-person service.
Exactly. The act of the officer giving you the ticket is the service. Is the service of process, and is also the in rem jurisdiction.
And therefore, in-personal jurisdiction.
In-persona, I'm sorry, in-persona jurisdiction.
I agree with that, and I'll leave you
Well,
to
sir,
appeal
I
on
would
that.
agree with that, but the issue is that would only apply to the inhabitants of your municipality. When your municipality is created, this is an officer created under the executive branch, okay? He doesn't have the authority to create judicial determinations on the side of the road. So when your municipality is formed, what happens is the state says,
Okay, so I want to also preface that this guy is an adherent of a guru known as Alfonso Fagiolo. He's a guy out of Pennsylvania, and he's also somebody that I do have some original content on, and I will be talking about him in a live stream at a later date, and he is adhering to Alphonse's strategery in terms of getting out of a ticket.
okay, you want to be incorporated, we're going to let you be incorporated, and we're going to give you the power to have executive authority, judicial authority, legislative authority, but that wouldn't apply to an everyday citizen.
And you have detailed all of that in your applications. I understand your position.
Okay.
Unfortunately, I disagree with them, and I've denied your application.
Can you give it to me in law where you can disagree with that? Can you show me in law?
So,
I mean, I've been looking.
Mr. Brennan, debate law. Again, I offer you the opportunity to be represented, so that.
Oh, I don't need to be represented, sir.
Let me finish this.
Okay,
I've
I'm sorry.
offered you the opportunity to be represented, so that you could have counsel on these issues as well. And it is up to you. You have the right to refuse that and to proceed. And I respect that if that's what you'd like to do.
Sir, I don't need counsel. I don't need a lawyer. I study as much law as a lawyer. In fact, I find that a lot of lawyers are very incompetent.
I mean, he's not wrong that there are a lot of incompetent lawyers out there, but I'm giving him the side eye for him saying that he studies as much as your average attorney.
Don't know the law. They belong to an association that is all hooked up with the court system. Who?
Because we're here for the trial.
Yeah, okay.
You can have that discussion off record anytime you'd like. That's fine. So we are ready to trial, and I just want you to understand that there may be consequences if you are convicted of the 340 charge. That could include jail time or significant fines if convicted on the 310B charge. And you're aware of that. All right. Fair enough.
Judge, I just want to make sure, because Your Honor had indicated that he was waiving his right to have a public defender, and he indicated he was not waiving his rights to anything. I want to make sure that he understands that once we proceed with this case, he is waiving his right to have a public defender or hire his own attorney with respect to it. I want to make sure before we start that he understands that.
All right.
Yes, I understand.
You do understand?
Yes, I have no desire to have a public defender or any bar member for that matter.
All right. Fair enough. You have absolutely have that right to do that. So we are here for a trial date. Generally speaking, the state will go first. The state, Mr. Butler will offer witness testimony, may offer evidence.
Okay.
That will be shown to you before marking and before acceptance. If you have any objections, any evidence that they want to pursue, let me know at the time that they offer that into evidence.
Okay.
There are court rules regarding relevancy. I understand you're not a lawyer. We're not going to hold you to those standards.
Mm-hmm.
But you understand there are legal precedents as to those objections as well. At the end of the state's case, you have the right, if you'd like, to move to dismiss the case, or to then proceed to your own defense. You don't have to testify. If you feel that you do not want to testify, there won't be any adverse inference drawn, merely because you chose not to testify. So be aware of that as well.
Okay.
But if you do decide to testify, they will be under oath. You will be sworn, and any statements are under oath.
Yes.
At the conclusion of the case, I'll offer you the opportunity to sum up, and you can provide a summary at that point as well.
Mm-hmm.
All right.
Yes.
Fair enough.
Thank you.
Feel free to have a seat.
Your Honor, I would move to strike anything that Officer Zibrin has to testify to, as any evidence that he has was obtained through violation of my Fourth Amendment rights.
So he's been.
All right. I'll note that for you.
Ground, sir?
A just super chatted with 99.99.
What?
They said been waiting a long time for this.
Uh-oh. It didn't come out. Uh-oh. Damn it. Wait, did you guys hear it? Or did I not hear it? Oh, it did it for you guys, but not me? Oh, no. Shoot. I am so sorry, guys. It actually did not go through for me.
And there is no basis to support that motion at law at present. But understand, making the motion and having the denial record for sure.
No, guys, I'm being serious. It did not actually go through for me.
Your right to appeal on any
that's my whole job here today, is to make an appeal. So we can meet again in another court.
Alright, I am so sorry.
Well, the appeal will be to the Superior Court.
Yes, I know where the appeal goes, and I know where federal court is also. So let's get on with this.
So you're not going to tell me how to run the trials, right?
No, sir.
Yes.
Absolutely not, sir. I would never do that.
I am in charge of court take form, and I want to give you a full, fair, and impartial hearing.
Yep, I appreciate that.
But understand,
No, don't.
Pranon 1990 just super chatted with 99.99.
Well, you got it for Mandy.
Try it this time. I love you, Artie Poo.
It worked for Mandy apparently, but not for me. I'm just Guys, I'm sorry. Thank you for that, but don't. If you're going to do that, don't. It's only working for Mandy and not me. I don't know why it's not working for me.
order of testimony, etc. All right?
Yes, absolutely.
All right. Fair enough. Patrolman, would you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth? Yes, I do. Thank you. If you could state, spell your name, your relationship to the Shrewsbury Police Department, please.
Sure. First name Michael, M-I-C-H-A-E-L. Last name Zibrin, Z-I-B-R-I-N. I'm a patrolman in the Shrewsbury Police Department.
Thank you.
And how?
What did he say? What department? Because people were asking about that.
Do you swear or affirm to tell the whole truth and nothing but the truth? Yes, I do. Thank you. If you could state, spell your name, your relationship to the Shrewsbury Police Department, please.
Sure. First name Michael, M-I-C-H-A-E-L. Last name Zibrin, Z-I-B-R-I-N. I'm a patrolman in the Shrewsbury Police Department.
I think he said Shrewsbury Police Department.
Thank you.
And how long have you?
Or is he said Ship Bottom?
Sure. First name Michael, M-I-C-H-A-E-L. Last name Zibrin, Z-I-B-R-I-N. I'm a patrolman in the Shrewsbury Police Department.
Thank you.
And how long have you been so employed by Shrewsbury Police Department?
Just under 3 years.
And do you have any prior police service prior to that date?
Served in Belmar as a Class 2, graduating in May of 2019. Transferred here as a Class 2 in September of 2019, and was hired full-time in January of 2020.
I'd like to direct your attention, if I might, sir, to March the 18th of 2022. Did you have an occasion to be working that day?
Yes, I did.
Were you assigned to any particular detail on that particular day, sir?
That was assigned to patrol.
And did you have an occasion to observe a vehicle in front of you?
Yes, I did.
And can you tell the court what, if anything, did you do with respect to the vehicle in front of you?
Sure. After a random plate inquiry on my MDT, the registered owner of the vehicle was determined to be suspended. A picture of that subject pops up on your MDT after you've found out that he is suspended, and I was able to determine that the driver of that vehicle matched the description of the person that popped up on my MDT.
So first, the picture popped up on your computer,
Yes, sir.
and then what did you do?
After that, when the light turned green, I initiated a motor vehicle stop in the area of 520 in Spirits Liquor Store.
Now, when it popped up on screen, did it indicate that Mr. Brennan was suspended?
Yes, sir.
And so you ultimately pulled him over, is that correct?
Yes, sir.
And did you have any conversation with him at that particular point?
Yes, I did. Went up to the driver window. I was able to determine at that point that Mr. Brennan was the driver in the driver's seat. Requested for his documents, his driver's license, registration, and insurance. He denied that he was going to give me any documents. I later requested it again and informed him that if I wasn't going to get any documents from him, that I was going to issue him the summonses for it.
So you asked him for his license, registration, and insurance?
Yes, sir.
And did he produce either of those?
No, sir.
And did you ask him again?
Yes, sir.
And did he produce them at that point?
No, sir.
As a result, what, if anything, did you do?
So I went back to my vehicle. Sergeant Polk arrived on scene and spoke with Mr. Brennan at his vehicle while I issued the summonses. Returned to the driver's window, gave him a summons, Mr. Brennan a summons for 39-340 for being suspended, 39-310B for being unlicensed, 39-329B for failure to give me his registration card, and 39-329C for failure to give his insurance card.
So why did you give Mr. Brennan a ticket for operating a motor vehicle without a driver's license?
Because in the state of New Jersey, if you've had a valid driver's license, it's now suspended on the provisions he's unlicensed.
And you gave him a ticket for failure to produce the insurance card and failure to produce the registration for what reason?
Because after requesting twice, he failed to produce his documents or even show me that he had any type of valid documents. So I went back to my vehicle and issued him summonses for it.
Did you have any conversation with him about his driver's license other than making a request for it?
I did tell him that he was being pulled over after a random plate inquiry for being suspended.
And did he indicate anything at that point?
No, he did not.
Judge, I'd like to have this document marked for identification, if you have, please.
So that the record is clear, why don't we start by marking the four summonses that are involved as S1, S2, S3, and S4 for identification. Again, on appeal, the appellate court will probably appreciate that that was the first markings. Any objection to that, Mr. Brown?
No objections at this time. Sir, I do object to that. That is not evidence. That's just a citation.
So according to this guy, the citation, that is the actual physical piece of paper that is the subject of this case, is not relevant evidence.
The citation is not evidence. So the relevance of that, I don't see the relevance of that.
Okay, your objection is for the record.
I'd like to renew that objection.
I've marked this 1, 2, 3, and 4. They are summons. Excuse me. 41264, 41265, 41266, and 41267. Consecutively, and that is S1, 2, 3, and 4. Over objection by Mr. Brennan. S5 has been offered for identification purposes only at present. Butler, if you haven't shown that to him, maybe you can describe that document.
So this is Mr. Brennan's driver's abstract, if Your Honor, please.
Objection, Your Honor. I don't see the relevance of a driver's abstract for this case.
Okay, so if you guys don't know, a driver's abstract is basically an entire history of your driving record. That it would include your registration, any citations you've had, etc., etc., etc. For the citation that he got, driving while suspended or driving while without a license when previously having a valid license, your driver's abstract would be very relevant for the state to prove its case. So I don't know where he's getting this idea that a driver's abstract would be irrelevant.
I will admit it for identification purposes and note your objection for the record.
Officer Zimmerman, I show you would have been marked S5 for identification and answer. Do you recognize that?
Yes, I do.
And what is that, sir?
It's a driver abstract.
And whose driver's abstract is that?
Mr. Brennan's.
And does the driver's abstract indicate that he's suspended on the date that you stopped him? Yes, Your Honor. You stopped him on March 18, 2022, is that correct?
Objection, Your Honor.
Yes, sir.
Leading.
I'll allow the question. It's a factual question.
Yes, I did. It's on the top note.
And his driver's license was suspended before that date, is that correct?
Yes, sir.
And with respect, you in fact were the person who ordered that abstract, is that correct, sir?
Yes, sir.
After the stop, it's your normal policy to request an abstract, is that
Yes,
correct?
it is.
And you ordered that?
Yes, sir.
And that's the result of your request?
Yes, it is.
And do you see the person who was operating the motor vehicle on March 18, 2022 in court today?
Yes, I did.
Could you please point him out for the judge?
Right here, sir.
Well, let the record reflect he's identified the defendant, Donald Brennan. Sure.
So reflected.
Judge, oh, that's the document you mentioned into evidence with the officer.
Thank you, Chairman. You indicated that you ordered this abstract. Is that correct?
Yes, it is, sir.
And is this the abstract that was produced as a result of your request?
Yes, it was.
And it's produced in the usual course of business from the police department?
Yes, sir.
Fair enough. Again, Mr. Butler has asked to move this into evidence. Any objections, Mr. Brennan?
Yes, I object. I don't see the relevance of the abstract being submitted into the record.
I will mark it into evidence and noting your objection as well. Ms. Butler.
I have nothing further to ask.
Mr. Brennan, this is your chance to cross-examine.
Yes, I would like to.
Understand the court rules provide that you only in the form of questions to them.
Yes, sir.
Statements,
I fully understand.
and directed to the testimony. So it's limited to that being testified to.
Yes. Officer Zibrin, how are you today?
Good. How are you?
I'd just like to accommodate you on your professionalism the day we stopped. You're very professional.
That sounds very sarcastic, but I don't know. He might actually be genuine.
And honestly, all the police here are very professional. I appreciate that. Officer Zibrin, how much constitutional training do you undergo? Yes, each month, say. Do you continue?
How much constitutional training do you undergo? I mean, I would say that's relevant with respect to the idea. If you phrased it better, it would be a far more relevant question. Like, I would say a relevant question would be how in a sense of, if he asked the officer how much continuing education do you get on aspects of the law, like on a regular basis, or like something to that effect, or how up to date are you when it comes to aspects of the existing statute. I would say that would be a relevant question. Here, it's wavering in a gray area between relevant or irrelevant, but I would agree with the judge here.
I'm going to allow the question.
Allow the question.
Back when I was in the academy, I believe we had about a month of 2C and Title 39 training.
A month of training?
Yeah, about a month.
Are you familiar with the Fourth Amendment of the Constitution?
Search and seizure?
Yes.
Yes, sir.
Do you feel that your stop using an electronic device could be a violation of a search and seizure?
No.
No, because it's not. Stopping because of an electronic device. Oh, I don't know if you guys missed that in the testimony. He ran his tag. Your tag is by its very nature public. So any officer can run your tag because it's right there out in the open, public information. So it's not a Fourth Amendment search violation.
Do you have a...
There is no, in other words, there's no expectation of privacy of your license tag.
Did you have any probable cause evidence to pull me over?
So I had reasonable suspicion to pull you over, which is what you need in the state of New Jersey to pull somebody over.
And what was that reasonable suspicion?
That you were suspended, that the registered owner of the vehicle was suspended.
And how did you acquire that reasonable suspicion?
So on our MDT, there's a system called InfoCop that we use. Two buttons, F1 and F5. F1 is a random plate inquiry, which we can do on any vehicle that we see. F5 is a full disclosure inquiry, which we need reason to run that plate in full.
So that's actually, I missed this part of the testimony. So the officer sounds like he's already had this question asked of him before. So he came prepared with the answer. So, and he just said that there's one, which does a basic rundown, and two is a more comprehensive rundown. And he says that in order to do the more comprehensive, they need an actual, a greater reason to do so.
I did a random plate inquiry on yours, and on the system, if there is something wrong with the registration or the registered owner of the vehicle, a random plate inquiry would represent that, and it would show that either your registration is suspended, expired, or the registered owner of the vehicle, driver's license, is suspended.
Okay, is that a common practice here in Shrewsbury?
I tend to do it if I'm at a red light intersection. I will look to see around me and randomly run any place that I see.
And do you know if that particular device is used in the enforcement of the transportation code?
Objection, Your Honor.
You refer to a transportation
Particular device.
I will look
I want to hear what his question was.
to see around me and randomly run any place that I see.
And do you know if that particular device is used in the enforcement of the transportation code?
Objection, Your Honor.
You refer to a transportation code.
The transportation title.
U.S. code or New
Yeah,
Jersey
United States. United States Title 49, Interstate Commerce Act.
So now, all of a sudden, we are now talking about federal statutes. Title 49 of the Federal Transportation Code. Why we're here all of a sudden, I don't know. We're about to find out.
Transportation code is what every code in the United States and every state is fashioned after. That's the controlling.
No, it's not.
Controlling code.
Okay.
So.
I understand that. Again,
Okay.
There's been no foundation made that is the controlling statute here. So I'm going to sustain the objection.
Maybe we have closed caption. Unfortunately, I don't have closed caption here. If you need help, I could try my best to translate if you're having trouble hearing what the judge is saying. but unfortunately, I don't have closed caption available for this video.
Okay, Officer Zibrin, have you had much training in the transportation code?
No, sir.
Objection.
No,
Your Honor.
irrelevant.
But that's all right.
Your Honor, Officer Zibrin is in.
Don't talk to me.
Now he's trying to pontificate to the judge while there's a witness on the stand. He's not supposed to be doing that. He's supposed to be asking questions.
Okay.
This is your chance to.
Officer Zibrin, you're enforcing the transportation code. That's what you're doing out here.
Objection.
You're writing.
And I'll sustain that. Again, Mr. Brennan, I understand where you're coming from.
Okay.
I understand you want to impose the transportation code, whatever that means, as the basis for a decision here. That transportation code has not been established as the relevant statute here, so I'm not going to allow you to continue questions in that line. All right.
Okay, let me see how I can rephrase this question. Okay. Title 30, Title 39. How much of experience have you had in the statutes under Title 39?
Judge, objection. That question is way too broad with respect to how much experience does he have with respect to Title 39? Judge? Way too broad.
Mr. Brennan, are you talking about New Jersey statutes?
Yeah, New Jersey statutes. He's enforcing New Jersey statutes, and in order to enforce that, he should have some knowledge of it or understanding of it and who it applies to.
So I apologize. I'm going to sustain objection only because of the vagueness of the question.
Okay.
How much experience have you had? If you'd like to ask about individual training, coursework, etc., I think that would be relevant, but the word experience is significant.
Okay. Officer Zibrin, did you have any verified warrants?
For what?
For me. Do you have a warrant? Any warrant?
No, there's no warrants.
No warrant?
No.
No
sir.
warrant. Have you submitted a probable cause affidavit into the record?
No, no.
Objection, Your Honor.
Again, there's been no foundation that one is required, so I'll sustain the.
I would say if I was going to be the state's attorney, I would say objection as to the relevance of it because it's irrelevant. Again, the issuance of a citation doesn't need a probable cause finding in the state of New Jersey. Or not. Let me rephrase that. A citation is in lieu of a probable cause statement. In other words, a finding of probable cause will be based on the citation and not on a separate document.
I object to that, sir. I take exception to that.
No, for the record.
Okay. Officer Zibrin, have you had training on this particular item that you use for running these license plates?
Objection.
I would actually say that's a relevant question.
Are you talking about
The license plate reader. I'm not familiar with exactly what they call it.
If the question would request training on the instrument that used for reading license plates.
Yes.
So I'll allow that.
Yeah, I would allow that.
So yeah, during my FTO period, I was in an FTO period for about a month, between December of 2019 to January of 2020 as a Class 2.
Okay.
There I received some training on the MDT that we were using and the technology that it's based on. Then when I got hired full-time in January, I went into another 2-month FTO period between January and March of 2020.
Are these an instrument that needs to be calibrated?
No, the MDT does not need to be calibrated. The license plate reader is updated every year, every day.
Okay.
Around the same day.
It's not a speeding device. It's a
But our info cop, every time we log in, re-updates from the DMV.
All right, thank you, Officer Zibrin. Okay, Officer Zibrin, are you familiar with...
That was going to say, it's not a radar gun. A radar gun does need to be recalibrated. The thing, only the database needs to be updated, not the actual... Whatever.
Privileged base usage of the road compared to rights-based usage of the road?
objection?
And the basis for that question?
It's because under our Constitution, so we have the right to utilize the roads. The entire transportation
He almost said it. So you don't get the bingo slot because you didn't say it.
code. I don't know if you've ever read it, but everything in it has to do with commercial activity on the road. Officer Zibrin.
Again, Mr. Brennan, you're asking standards that are not necessarily issued in this trial.
Well, I'm being charged
So I'm
under
going
that.
to sustain the objection.
Okay. Okay. All right. You just had a question that you got from me there. You foiled me. Okay, Officer Zimmerman, I appreciate your testimony today. Do you have any evidence that you have submitted to the record aside from a citation?
No, sir.
No, sir. Okay. Thank you, Officer Zimmerman. Appreciate your testimony.
Thank you, Mr. Brennan. Thank you, officer. Any other?
You did get the abstract, is that correct, sir?
Yes, sir.
And the abstract is evidence with respect to this particular matter, is that correct, sir?
Yes, it is.
I have nothing further.
You had the chance to recross on that issue.
I object to that, Your Honor. I don't believe that an abstract is evidence. I mean, the abstract is irrelevant to this case, to this particular matter, so I don't see the relevance of it.
Understand, and that objection has been noted at the time it was offered into evidence.
Okay, thank you.
So that is continuing. All right. Fair enough. Thank you.
Stay rest.
Thank you, Your Honor.
So the state is rested, meaning that there will be no more testimony or evidence presented. At this time, you have a right to move to seek dismissal of the complaint.
Yes, sir.
And or to continue presenting the defense.
I would definitely move the court to seek dismissal. The court has not provided any evidence of jurisdiction in this matter. Just because someone says they have jurisdiction doesn't mean they have jurisdiction. There's rules of the court that govern the courts of New Jersey. There has been no proper service. I can't summon you to court without proper service. You have no more rights here in municipal court in Shrewsbury than I have as a citizen, a United States citizen. Their court has supplied no evidence that I've been operating in commerce according to the statutes of the Transportation Code. There's been no subject matter determined. There's been no pleadings submitted to the record for a cause of action. There's been no elements to support a cause of action, and I would move that the state dismiss this.
Mr. Butler.
Judge, with respect to this particular fact that Mr. Brennan was operating a motor vehicle on the highways of the state of New Jersey, Judge, he is subject to the jurisdiction of the Shrewsbury Borough Municipal Court. With respect to this particular matter, in this particular juncture, the state has given all reasonable inferences at this particular point in time, and given the state all reasonable inferences with respect to this particular matter, the state has made out a prima facie case, and the motion should be denied.
I object to.
1 second.
Okay.
Are you finished, Mr. Butler?
Yes, Judge.
I object to that.
It is a motion. It's not an objection.
Okay. The Shrewsbury Municipal Court does not have jurisdiction because they say so or because I'm operating a vehicle on the road. Shrewsbury has jurisdiction, territorial, because of the minimum contact rule. So they have territorial jurisdiction to bring me into court. But that's only one leg of the stool. They still need to acquire in personam jurisdiction and subject matter jurisdiction.
But they did. But they did, though. By the officer giving you the citation, and the fact that the municipal court is there to hear traffic offenses, the in personam and subject matter have been satisfied.
How can I defend against a charge when I don't even know what the charge is? A bunch of numbers scribbled on a piece of paper, a summons, when a citation, sir.
This is no longer a motion. This is a statement, and
Okay.
I'd be happy to hear anything you'd like to tell me. But it is your time for testimony. However, the subject matter of your discussion today, or just now, has been again an argument that there is no in personam or subject matter jurisdiction, and that there was not a proper service of the summons upon you. Again, all of that has been raised as your argument, and the court has denied it on the record in the past. So that's where it stands, and it's again, your objections are preserved for appeal.
Okay.
All right. Based on the testimony that has been provided at present, feel free to sit down. This understanding Patrolman Zibrin testified that he was on patrol on March 18, 2022, the date of the stop. Here in Shrewsbury, that he observed the defendant's vehicle and instituted a random plate reading through his equipment in his vehicle at that time. He indicated that the plate reader indicated that the owner of the vehicle had a suspended license, at which point Patrolman Zibrin indicated that he then did an individual check on the defendant owner, and the description matched for the driver, and indicated that the driver had a suspended license. At that time, he initiated the stop and indicated that he pulled over the defendant's vehicle, requested driver's license, registration, and insurance documents on 2 occasions. When the defendant refused to produce those, Patrolman Zibrin testified that he then indicated that he issued the 4 summonses that are identified as S1, 2, 3, and 4. At this juncture in the trial, my purpose is to review the testimony that has been offered and any evidence that has been offered as well, to see if the state has met a threshold burden of moving forward with the case. And at that point, the statutes and case law provides that the state is provided with all reasonable inferences in support of its motion. I do find that there is sufficient testimony that has been uncontroverted in cross-examination to believe that the patrolman did in fact both use the plate reader to assess the license situation for the driver, that did indicate that there was a suspension for the driver, and had reasonable and probable cause to stop the vehicle when confirmed that the driver was on the suspended list. Again, awarding all reasonable inferences in favor of the state, I believe we're going to finish this night. So we're going to motion to dismiss at present, and then we renew the public should you choose to do. Mr. Brennan, this is a part of the trial where you have the right to provide your own testimony or any documents that you wish me to see or hear, subject to objection by Mr. Butler, or to choose not to testify. Again, as a defendant, you have that right not to testify. You won't be any adverse inference drawn if you choose not to.
Yes, I would like to testify, sir.
All right, I'll ask you to raise your right hand. Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes, sir, always.
Fair enough. Feel free to, you can testify from your seat.
Okay, I'd be better standing up. I'm fine. Officer Zibrin has created an absolute violation of my constitutionally protected rights. The court has violated my substantive and due process rights under the 5th and 14th Amendment. They have not provided proper service. They have not proven subject matter jurisdiction. Territorial jurisdiction does not allow a court.
Object because he's not testifying as the incident. He's again making arguments about it.
In other words, the reason why he's objecting is that he's not giving testimony as to the facts of the events that took place, but rather making legal arguments, which that's not really what he's supposed to be doing when he's testifying.
Jurisdiction.
Mr. Butler's objection is accurate, but I'm going to let you continue. And all of this is available in the record for the purpose of appeal.
Yes.
So you need not institute those arguments for the motions that I've already done. I understand your position.
Yes, okay. So basically it doesn't really matter what I say because the state is already determined. Officer Zibrin had probable cause. He had no probable cause that I was in the commission of a crime. He violated my rights by doing an illegal search and seizure and then decided he had probable cause.
I'm going to allow
which I don't believe there is probable cause. There is no probable cause. In order to have probable cause, Officer Zibrin would have had to bring me before a magistrate to determine whether that's probable to cause, to issue the warrant to seize me.
So what he's basically arguing right there is that once the officer ran his plate, discovered that he had a suspended license, he was to first go to a magistrate, provide a probable cause affidavit, get the sign off, and then go back to him and give him the citation.
But none of that was done. There has been no procedural process done correctly by the town here, by the state. There's not. The state has not.
So the problem that he's missing here is that the courts have the courts have recognized that that what he's suggesting is untenable. You know, if an officer sees somebody burglarizing a business, right? He's actively burglarizing the business. The officer doesn't have to go to a magistrate with a complaint saying, "Hey, I just witnessed this dude stealing stuff from this 7-Eleven," and then come back and get the robber. The officer is allowed to arrest, and if he finds that there's probable cause to arrest him. It's only what the courts require that once you're arrested, and you have to, within a certain amount of time, bring forth that probable cause affidavit to a magistrate to sign off on. It has to be usually within like 24 to 48 hours. You have to have that probable cause affidavit brought before a magistrate. That's what's required. It's not required that the officer can literally do nothing until he gets a probable cause affidavit signed by a magistrate before he can act when he sees a crime being committed in front of him.
Provided any witness. The state has not provided any evidence. A citation is merely, here's the day you come to court on this time at this thing. That's not evidence of anything. It's merely a citation. And so the court is moving against me without jurisdiction, in violation of my constitutional rights. And I don't believe that this is acceptable. It's horrible. It really is that's done. There's many people that come before your courts that acquiesce to whatever you guys throw at them. I'm a constitutionally protected citizen, just like every one of you. And certain rules apply to us, and laws apply to us. The statute, you have not proven in the statutes that any of these statutes apply to me according to the statutory definitions laid out right in the statutes themselves. But yet and still you'll continue to move the court to me for what reason I have no idea, other than for monetary gain. And that's just unacceptable. It's not something that I'm going to allow as a citizen. I'm not going to allow that. I'm not going to allow public servants to violate my rights. We have a whole country. I'm sure you're all aware of what's going on in our country with people in high places that do absolutely corrupt things. Down here at the lower level.
Oh my God! Now he's pontificating. Again, he's supposed to be testifying as to the circumstances of what happened that day, not pontificating in front of the court.
I'm going to ask you to refrain, to limit your testimony to that which is relevant to
Okay,
the
I appreciate that.
issue. I understand your position. I happen to disagree with it.
Hey, thank you, Smitty, for becoming a member.
Well, I didn't have any.
Mr. Brennan, again, I disagree with, and I have on the record indicated my disagreement with your legal conclusions. I think are incorrect. Again, that is for you to pursue an appeal if you choose to. But I'm going to ask you to limit your testimony to that which is relevant to the alleged violations. And relevant in legal term means, is it more or less likely to prove an element of the offense?
Yes,
We'll lead to that.
the state has not proved their case. They have not provided evidence. They provided a citation.
Providing argument with respect to summation. He has not said anything with respect to the charges. Everything that he said is with respect to his summation, Judge. That's what he's testifying to.
In other words, the prosecutor saying he's giving his closing argument, not his testimony as to the facts of the case.
You're not an attorney. We're not holding you to those rules. But this is the time of the trial where you could provide factual testimony about the relevant ordinance, the relevance.
The factual
Smitty, for the
testimony is that there's been no evidence submitted into the record whatsoever
Right,
that those statutes apply to me.
Oh my God.
There is none.
All right.
And even in the statutory definitions, it clearly states.
I understand your position.
Okay.
Anything else you'd like to?
No, I rest.
Sure. Fair enough. Generally speaking, at this point, I will allow summations. Summations being generally a summary of what has transpired in the case, and at that time, your opinion as to whether there should be a guilty or not guilty finding in the case. All right, and I'll ask you to limit to that extent. All right. So I'll hear you, Mr. Brennan. Anything else that you'd like to add?
No, sir. All right, this is a dead end.
Mr. Butler?
He's so mad.
I think that you have Officer Zipper's testimony, Judge. There's no question that Mr. Brennan was suspended. No question that he pulled him over. No question he had the proper lookup. He verified that it was in fact him. As of his documentation, he didn't provide any of his documentation, Judge. Quite frankly, his driver's license is suspended. He was suspended for several different reasons, Judge. I think based on the overall circumstances, Judge, the state has proven its case beyond reasonable doubt as to all of the charges.
Fair enough.
Just for the record, Your Honor, my driver's license was expired in 2019, and I never ever went to have it reinstituted ever.
Okay.
I'm going to ask you about that in a moment.
Yes. Okay.
If we get to that point in the proceedings. Fair enough. So for the purpose of the record, Patrolman Zubrin has testified that he was on patrol here in Shrewsbury on March 18, 2022, observed the defendant's vehicle, indication at the intersection of Broad Street and 520 and the summonses themselves, that through the use of a plate reader, determined that the owner of the vehicle surveyed, was on the suspended list. Patrolman Zubrin indicated that the description of the owner matched the operator, at which point he then initiated an individual inquiry into the owner of the vehicle and confirmed that the owner of the vehicle, the defendant, Donald Brennan, was in fact on the suspended list, and that his license was suspended at the time of the operation. Patrolman Zubrin credibly testified that he pulled him over at that time. Explained the reason for the stop, requested that the defendant provide both license, registration, and insurance card. Patrolman Zubrin indicated that Mr. Brennan refused, and Patrolman Zubrin indicated that he advised a second time that if he did not produce those documents, that he would issue summonses, and the defendant refused to provide those documents. At which point, Patrolman Zubrin indicated that he did issue summons number 41264 for a violation of 39340, driving on the suspended list. Summons number 41265, a violation of 39310B, driving without a valid license when there had been a valid license in his possession, in his history. Summons number 41266, violation of 39329B, failing to provide a registration certificate for the vehicle. And summons number 41267, a violation of 39329C, failing to provide an insurance card for the vehicle at the time of the operation. Patrolman Zubrin testified that he, thereafter ran a driver's abstract, confirmed the driver's license suspension for the operator that has been marked in evidence as S5 for identification and evidence. I note for the record that all exhibits S1 through 5 were marked into evidence of the objection of Mr. Brennan, as indicated on the record. On cross-examination, Patrolman Zubrin indicated that his understanding was that he had reasonable cause to stop the vehicle based on the information given from the plate reading. Having had previous training for approximately 3 months in a prior agency in 2 months in Shrewsbury on the unit he called an NVT unit. He indicated that the unit was properly operating on the day of the stop, and software is updated daily from New Jersey, such that the information that he received on that day he believed to be accurate. Excuse me. Mr. Brennan has testified that he believes that there was no proper service of the summons, of any of the 4 summonses that were issued, that there's been no evidence of his operation, and no pleadings sufficient to provide evidence of that operation or a violation of any statute, and that the court lacks both lack of service in persona and in jurisdiction for the offenses. All of those arguments had been raised in prior court proceedings and denied by the court on the record for those purposes. I note that Mr. Brennan again intends to rely on interstate commerce rules and some vague indication of standards that are not relevant to New Jersey statutes or Title 39. And I note the court takes judicial notice that upon the issuance of a license and in order to operate a motor vehicle, license holders motor vehicle license holders in New Jersey consent to jurisdiction under NJSA Title 39 for the operation of motor vehicles.
You hear that? When you get a license, you agree you're supposed to be following those rules. But even if you don't have a license, you can still be hemmed up. I wish the court would clarify that if you're driving without a license, you're still going to be hemmed up, even if you never got one in the first place.
Registration of motor vehicles and the maintenance of appropriate licensing. I do find by very clear and convincing evidence and beyond a reasonable doubt that the testimony of Patrolman Zubrin is credible. I have observed his testimony. It corresponds with what appears to be appropriate police procedure, both in terms of the initial investigation, the initiation of a stop based on probable cause, and it is supported by the evidence provided, including the abstract, motor vehicle abstract that I've indicated as being prepared in the ordinary course of his duties as a police officer, and therefore appropriate record under the record exception to the hearsay rule. Again, there has been no credible testimony by the defendant, although advised that he did not need to testify as to same. But there's been no credible testimony provided that that denies either the operation, the failure to have a license, the failure to produce, or an explanation for the failure to produce either an insurance card or registration card as well. Mr. Brennan has indicated on the record that his license did expire in 2019 and was not renewed after that date. From that credible testimony, and again having the ability to review the demeanor of the witnesses, I do find that the state's testimony is much more credible. I do find that the state has met its burden of proof.
Shocker! Shocker, the state's met its burden.
Beyond a reasonable doubt, and that it is appropriate to enter a guilty plea on the following offenses. Summons number 41264, 39340, driving while on the suspended list. I believe the summons 41265, the 310B charge, driving without a valid license after having had a valid license in New Jersey, is in effect a duplicative charge, as the elements for operation would be the same in either case. I do find it appropriate and enter a finding of guilt on summons 41266 failure to provide a registration card, and summons number 41267, failure to provide an insurance card at the time of the stop as well. We are now at the sentencing.
So it sounds like the judge found him guilty on the suspended license, but not on the driving without a license while previously having a valid license. I think because he said it was a duplicative charge. I think he took out one of the charges.
Please, Mr. Brennan, you have the right to provide any testimony that you'd like as to sentencing. I have reviewed your driver's abstract, and for the record, it appears that you were convicted of a 340 violation, driving while on the suspended list on September 16th of 2021.
So he was suspended previously. Excuse me, he was convicted previously on a suspended license charge. So this is his second.
Jurisdiction Q35, I'm not quite sure where that is. And then again, September 3rd, April 24th of 2016, in jurisdiction Z32 as well. There was a 340I parking violation that triggered the 340 on September 3rd of 2009. That is not relevant for sentencing purposes. But unless there's an indication that this information is incorrect, Mr. Brennan, this would be a third offense for the 340 violation, and a first offense as to the other two violations that I've indicated on the record. And you understand that a third offense of 340 violation I'm required to impose a fine of $1,000.
Woo! $1,000 fine.
Court costs provide loss of good driving privileges for a maximum of 6 months, from 1 day to 6 months. Once you were drivers, if you try to reinstate your driver's license after it having been expired. Revocation of any registration, since this violation falls within 5 years of the prior.
Thank you for the $5, Kraken.
Jail time, 10 days of jail.
Mandatory 10 days of jail time.
There's indication that if a motor vehicle offense occurred along with this 340 violation, there'd be an enhanced 10-day period. But based on the finding of the court today, there is none that would enhance that sentence. So you are subject to 10 days of jail time as well. Is any of that information incorrect? Is there anything you'd like to tell me before I impose sentence?
Yeah, I believe it's all incorrect because I don't believe that any of this applies to me pursuant to the statute, and the court has not proven that it has. Nor has the court proven its jurisdiction, which is absolutely a threshold matter in order to move a court against me. You're violating my constitutional rights, my due process rights, and I don't know how you could allow that to stand in your court, sir. I really don't.
Again, I understand.
You charged me with a registration.
Mr. Brennan, but I note that for the record and note your objection.
You've charged me, Officer Zibrin has written me a ticket for not showing him a registration when he pulls it right up on his computer. We live in the age of...
Mr. Brennan, I apologize, we're beyond that part of the case where you could provide testimony as to...
Yeah, too late now.
Okay.
Again, the statute required that you provide it is the bottom line. And there was no indication that you did as part of the testimony. Again, while I recognize the objections that you make, I am required under the statute to impose, as to summons number 41264, a fine of $1,000, $33 costs. That's a period of
2007.
Thank you very much. There is a $7 addition for a particular fee that would be.
The state also had to throw. By the way, there was also a $7 fee, Judge. Oh, yes, $7 on top of the $1,000 fine and the $33 a car cost. That sounds like freaking New Jersey. Gonna nickel and dime you every single way.
$33 costs. I have to impose a loss of driving privileges. I will do that for a period of 60 days. Revocation of any vehicle registration that you have pending for the period of your license suspension. And I must impose jail time of 10 days. As to summons numbers 41266, failure to produce a valid registration certificate, I will make a finding of guilt. As indicated on the record before, impose a minimum fine of $157 and $33 costs. And as to summons 41267, again, impose a guilty finding and a fine of $157 and $33 costs.
So, in sum total, it's about $1,400 in total fines plus 10 days of jail. Yeah.
As to all three of those summonses, you certainly have the right to appeal my decisions. Understanding that appeal right only runs 20 days, so the notice of appeal has to be filed within 20 days of today's decision. And you can go online to, you can, if you wish, we can send you the link to the Monmouth County Superior Court's office where you can file that notice of appeal manually or electronically if you wish to do that.
No thanks, I'm good.
All right. And I will mark summons number 41265 as being dismissed on the court's motion.
Oh, he's gonna appeal. He already said as much.
Being taken to the county jail today.
Yes, I am.
And the care of any dependents or any other persons
So now he's asking about his dependents because he's going to be sent to jail now.
would prevent you from being taken to the county jail today.
Yes, I am.
And in what situation is that?
My wife and my grandson.
Are you a legal guardian for your grandson?
I'm not a legal guardian, but I take care of him in certain days of the week. Yeah.
And is your wife disabled in any way?
No.
Unfortunately, that doesn't constitute grounds with which to suspend the jail term immediately as well.
Well, I would ask the court to.
Thank you,
to
Kira,
stay
for the
there.
$4.99.
On what grounds?
On the grounds that I think it's the moral thing to do. I mean, I'm not going to flee. Let's set a date where I'll come. This is going to be appealed, obviously. So, I mean, the appeal is going to stay this decision. So, I mean, it's going to be appealed tomorrow.
Well, I understand you have your position as to that. Mr. Butler?
There's no flight risk or anything like that, Your Honor.
Mr. Butler, in a position on the request of the stated position and sentence.
Judge, he wants, I have no objection to that. He knew what he was getting into when he came in here, and that was his intention the whole time, was to appeal. I don't necessarily think that he has any real reason to appeal, but he has his reasons that he wants to appeal, and I don't want to interfere with that. So if Your Honor is inclined to stay the sentence for 20 days, and if he doesn't appeal it within the 20 days, then he has to turn himself into Shrewsbury Providence.
All right. Mr. Brennan, again, because you've raised what you believe are significant arguments as to constitutional elements. I will stay the imposition of the sentence for a period of 20 days to allow you to file notice.
So the judge is gonna throw him a bone, and they are staying the imposition of the sentence for 20 days, pending his appeal sentence. So they give him that at least, so he's not going to jail today.
Appeal. You will serve that notice of appeal on this court within 20 days if you do file. If it is not served on the court within 20 days, then you are to remand yourself to the sheriff of Monmouth County on day 21.
Understood.
All right. You're still residing at 444 Cable Avenue in Beechwood?
No, sir. 52 Bowline. I've already know.
So that's the end of that. That's really all there is. So that's the end of that. He as we all expected, he lost. He made some ridiculous arguments that a driver abstract and a freaking copy of the citation is not relevant in a traffic case. I don't know where he got that idea. He exhibited a typical SovCit arguments of jurisdiction. The municipality has no authority to impose statutes against me. I have the right to travel. This is all commercial, yada, 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 yada. And he failed miserably. But I promised you guys an active arrest, and I'm giving you guys an active arrest to close out tonight's live stream. Now, where is it? Nope. Nope. Nope, that's not it.
All right.
Nope, that's
This is Angela.
nope. What the hell is? I know I had it. Uh-oh. Think. Aha! Found it. Found it. Oh, I forgot this one's also. Oh, wait. I gotta there we go.
Before we get started, I want to record that I'm the beneficiary of the trust in question.
Okay, well, be warned. I honestly feel like I should have saved this case for a bingo night, because I'm pretty sure we would get at least 3 winners by the end of this 6-minute video. That's how bad it is.
Here in sui juris.
Sui juris and beneficiary.
Without prejudice, as a special appearance.
Come on up, sir. I'm fine here. You can hear me here. I'll be louder if that's okay. So, with all due respect, I do not take orders from the servant, so thank you very much. I'm here in sui juris and propria persona without prejudice as a special appearance. I, comma Nathaniel J. Lopez, comma beneficiary and sovereign.
I, Jonathan, colon hyphen. Yeah, we're getting to that too.
Here under fraud, menace, duress, and extortion is your share title. This is a social security certificate trust action which you are now a real party to. This is military admiral.
Military admiralty. I see. You hear what I'm saying? All the bingo boxes are being clicked in the first 2 minutes.
You know what maritime law is? It's naval law.
Naval law. Oh, by the way, this is Oklahoma.
Oklahoma's a long ways from the ocean.
Oklahoma's a long ways from the ocean.
Do you plead guilty or not guilty? I do not plead.
Hey, on civil law, what's up, man?
I do not plead.
I do not plead.
Okay, obstructing an officer, resisting an officer, possession of dangerous. Before we get started, I would like to say.
So if you didn't hear what he was charged with, it was threatening an officer, resisting an officer, and possession of a controlled substance.
Jurisdiction. I'm asking what jurisdiction is the court under. Oh, I thought you said you would like to. I would like to establish what jurisdiction the court is under. State of Oklahoma.
State of Oklahoma.
What jurisdiction?
State of Oklahoma.
Is this a criminal or civil?
Criminal.
Under the Constitution, the court is only granted two different jurisdictions, which is criminal and the common law, and the other is military or maritime admiralty law. So we're in criminal. Criminal. In which of these two criminal jurisdictions is this court intended to try? You got me on that one. Yes, common law and military and admiralty. This would be common law or state statute. So this is common law. I'd like the record to be so that.
So if you guys didn't hear it, he's going for the talking frog script. So he's like, is this common law or military admiralty? And the judge just said it's either common law or the statutes of Oklahoma.
This is common law. Oh, this all should have been recorded.
Thank you, Vera, for the $10. He's also said that this is being recorded, and the judge just said, have you requested for a recording from the court recorder or something like that?
I know you're right there, you start hearing it. Did you place money up for a court? No, but that is the stenographer's responsibility to record it. Apology. I would like it on the record. Hey, go place it on the money. $25 for a court reporter.
$25 for a court reporter.
You want to go do it real quick? So I'd like it on the record that he said this is under the common law. Do you want to put? I do want this on the record. Well, then we'll put us the $25 there.
If you want this on the record, go pay the $25.
For the jurisdiction of Oklahoma, Squid County, 15th Judicial District, State of Oklahoma. Since this is common law, we are in the court. Are you hearing no plea? No, I am not pleading.
I do not plea.
You're hearing no plea. I am not pleading. I am here in propria persona, without prejudice, as a special appearance. Well, since you're not pleading, I'm going to show a not guilty plea for you. I object. I do not consent to that.
I do not consent. The judge just said I'm going to enter the plea for you.
My counsel is able to plead for me. Are you my counsel? But you're not entering the plea. I am not entering the plea because I do not understand the nature of the charges. Since we're not able to move forward through this possession, I've got to take you into custody then.
So, and since now the judge, if you didn't hear that, the judge just says, since we're not able to move forward, how about I take you into custody then? That's what the judge just said, if you didn't hear it.
I do not. If you touch me, bailiff, I will charge you for battery and assault.
If you touch me, I will charge you for battery and assault.
This is against my constitutional rights.
And as you can see there, he's getting hooked up.
I'm charging you guys with battery and assault. For what? For what? For what?
Because I can't get through. I tried to give you a chance to, you won't let me enter a plea by movie.
I'm not entering the plea for you.
I know, I was going to enter it for you. But
That is practicing law from the bench.
Practicing law for the bench.
I do not need you to do that for me. Only me or my counsel can determine a plea.
Okay, so does you or your counsel want to enter?
I am not entering any plea because I do not understand the nature of these charges. And as my constitutional right, I have a right to understand these charges, which I do not understand
I'm
the nature
going
of
to
these
take you into
charges.
custody and appoint you an attorney, Mr. Just So.
I do not want this.
Well, I'm going to take you into custody, and I'm appointing an attorney for you.
I do not accept the appointed attorney.
Okay.
What
Okay.
am I under arrest for? What am I under arrest for? I want it on the record. They're not telling me why I'm being put under arrest, so I'm not consenting to this. You have to tell me why I'm under arrest. Is there a crime?
Don't worry, there's more. It's very brief. It's only like 14 seconds, but it's okay. So I assume this is the cameraman who is now following him.
What is he under arrest for?
Well, I'm not resisting. I'm not resisting.
You are resisting.
I am not
You're
resisting.
compliant.
And that's the end of that. I'm gonna end it there. I actually have I've accumulated additional original content for you guys that's gonna be upcoming soon. But those are the big those were the big ones that I wanted to show you tonight. I hope you enjoyed it. I'm happy to be back and live streaming for you. And yeah, hit that like button. Hope you just subscribe if you haven't done so already. Join my Discord as well. Thank you again to RA and Pronon for the very generous super chats. Again, I apologize for not having the jump scare working. I really am sorry about that. And thank you all to the others who have sent super chats. Thank you, Mandy, of course, for being there as my producer as always. Goodness. You did it. At the very least, you did jump scare Mandy. I hope that's at least some level of reconciliation. But I'll make sure to confirm that the jump scares are working before going live next time. But thank all of you for the all of you as well for the other super chats as well. And yeah, thank you guys again. I appreciate it. I gotta go nurse this headache. I don't even know why I still have it. But thank you. Take care. Bye.